Thank you all for joining us for our presentation today. My name is Dustin Saldariaga. I'm a senior associate at Scott Legal PC, and today we'll be talking about a few common visa options for investors who are looking to come to the US to start or grow a business. We'll also be going through some of the most common questions that we receive about these visa options. A few things before we get started. Some of you may know that Ian Scott, the founder of our firm, actually is currently on an E2 visa, which is one of the visa options we'll be talking about today. And his experience navigating the process really does inform the way that we work with our clients. We're proud of maintaining a very client-centric approach and keeping in mind, the aspects of the process that may be confusing or difficult. We try to keep all of that in mind as we work with our clients and for our clients through the process. Our firm is a full-service immigration firm, so whether you have questions about investor visas or family visas, humanitarian options, whatever it is, please don't hesitate to reach out to us for help. And our firm does focus on investor visas that we consider to be uniquely high risk. Oftentimes that means that they are smaller businesses or businesses with a lower investment amount. We will be continuing this webinar, which is part of a series, by doing about 2 webinars a month, and we do those on a variety of topics. We do post all of our webinars afterward on our YouTube channel, where we also keep a number of shorter videos on a variety of topics. So do check out our YouTube channel. Just go to YouTube and search for Scott Legal PC. At the end of this webinar, we'll be sending out an email with a link to our YouTube channel, as well as the PowerPoint that you see on your screen. And we'll also send you a link where you can sign up for our future webinars, as well as a link where you can sign up for a consultation. So if you have questions that are unique or specific to your situation, sometimes it's better to schedule a consultation rather than disclosing any sensitive information on the webinar. We're very fortunate to have Ian Scott, the founder of our firm, joining me for this presentation. Ian will be speaking about 2 of the 4 options we'll be talking about today. He'll be speaking about both of the green card options, both the EB2 National Interest Waiver and the EB5 Investor Visa or green card. I will be speaking about the E2 visa as well as International Entrepreneur Parole. All right, without further ado, we will get started. If you have any questions, don't hesitate to share them through either the chat box or the Q&A box through Zoom. We will be actively monitoring those, and we'll either answer the questions right when they appear, if it's relevant to where we are in the presentation, or we'll save them for the end, but we do plan to get to all of them. With that, let's talk a bit about the 4 visas we'll be speaking about today. The E2 visa, which is a non-immigrant visa, the National Interest Waiver for Entrepreneurs, or NIW, which is a green card option, the International Entrepreneur Parole rule, which is not a visa or a green card, and we'll get into a little bit more detail about what that is, and the EB5 green card. The E2 visa is what we'll start with. This is the most common visa that we assist our clients with. And part of the reason for that is it is a wonderful option for someone who wants to come to the US to either start a business, to purchase an existing business, or to start a franchise. The E2 visa is only available to individuals who are nationals of a treaty country. There are dozens of treaty countries. They are listed on the US Department of State's website. So step 1 would be to Google E2 treaty countries, and you'll see the list from the US Department of State. If your country is on that list, we would typically recommend that you consider an E2 visa. Reason being, the E2 visa requires a relatively low investment amount that is proportional to the type of business. There is a minimum that we do encourage our clients to aim for, which is $100,000. Although, as I mentioned before, it is possible to invest a lower amount, and we do frequently help our clients who are pursuing that route. The other reason the E2 visa is a great option is it can be renewed indefinitely. So as long as you and the business remain eligible, you can continue renewing the visa and growing your business in the US. You can also bring family members. Children can study in the US, and a spouse will automatically receive work authorization upon entering the US on an E2 dependent visa. We'll quickly go through the E2 visa requirements. As I mentioned, you must have a passport from an E2 treaty country. You cannot be a lawful permanent resident or a citizen of the United States. You must have citizenship from a treaty country. You must make an investment into the business. The funds must be at risk, meaning they have to have actually been spent on items, business, office space, inventory, things that are necessary for the business to operate. And the investment must be substantial. We'll talk a little bit more about that in the next slide. Finally, if you are purchasing the business or making a significant investment into an asset that's necessary for the business, such as an office space, you may use an escrow agreement, which is a great option if you're concerned about your funds being at risk before you've been approved for the visa. The third requirement is that the business cannot be marginal. What that means is that the business needs to employ US workers. We typically recommend at least 3 full-time equivalent US workers within 5 years of operations. The business must be real and operating, meaning that at the time you apply for the visa at the consulate, at the time you attend your interview, you need to be willing and able to say to the officer that all you need is to receive the visa for you to be able to come to the US and start operating the business. The E2 visa is not intended for someone to come to the US and at that point start looking for business opportunities. You really do have to have already lined up office space, created the business entity, purchased those things that are necessary for the business to begin operating once you've arrived. Also, if this is a business that requires licenses, such as a restaurant that may need health permits, you need to have lined those up before your visa interview. You also need to be coming to the US solely to develop and direct the E2 enterprise, meaning you cannot work for other businesses. Excuse me. You also need to be qualified to run the E2 business, either through your experience or your educational background. And also, typically, you need to be focused on developing and directing the business as opposed to providing a service to customers. To take an example, if you're looking to start an accounting firm, it's important that your aim within at least the first year or two is to hire accountants who will provide the accounting services rather than you being the accountant who's providing those services. Your job should be networking, marketing, building the business, hiring employees rather than directly providing the service. That is especially important if you're applying within the US through USCIS. If you're already here in another status and are changing to E2 status. But if you're applying at a consulate, it is still important to keep in mind and to strive for. You must own, I'm looking at the 6th bullet here on the list, you must own at least 50% of the E2 company. So that means that you can have a 50-50 ownership agreement, and the other person can be anyone. They can be a US citizen, they can be a lawful permanent resident of the United States, they can be a citizen of a non-E2 treaty country, or they can be a citizen of an E2 treaty country. If you have 50-50 ownership shared between 2 individuals who are each citizens of one or more E2 treaty countries, then the company can have the nationality of both individuals. And what that means is that you can hire E2 employees from either E2 country. So let's take an example. A simple example would be a Canadian. Canada is an E2 treaty country. A Canadian owns 100% of a company in the US. They, once approved, would be able to employ E2 employees who receive an E2 employee visa to work for that company. The E2 employees, however, must be nationals of Canada. If the Canadian owner instead owns 50% of the US company and a German national owns the other 50% of the company, Germany is also an E2 treaty country, then that company could hire E2 employees from either Canada or Germany. Finally, you do need to have the intent to return to your home country upon the expiration of the E2 visa. The E2 visa is a non-immigrant visa. What that means is that you are not supposed to use the E2 visa to come to the US and then to adjust status to a green card. You need to have the intention when you apply for the visa and when you enter the US on the visa, as well as if you extend the visa from within the US, or extend your status from within the US. Each time you do any of those actions, you represent to the government that your intention is to leave the US at the end of your visa or the end of your status. Now, that's not to say that you cannot adjust status while you're in the US on an E2 visa. If you enter the US and at that time you truly don't have the intention to adjust status, but over time your business grows, and you end up realizing that a green card is a good option for you, you can down the road adjust status. However, what's important is that at those moments that you're entering the US, applying to extend your status or applying to renew your visa, you don't have the intention to enter the US for the purpose of adjusting status. It is okay to not have a home abroad. The E2 visa actually has quite a low bar to show non-immigrant intent. So you do not have to own a home abroad. However, you do need to intend to leave the US at the end of your status. One of the most common questions we receive about the E2 visa is how much investment is enough? And as I mentioned before, our firm does specialize in what we call risky cases. And oftentimes what that means is cases where the investment amount is low. We consider a low investment amount in general to be anything below $100,000, but that is a very broad statement. There are a lot of nuances to that. First of all, the required investment amount will really depend on the type of business. If you are starting a manufacturing company, let's say a company that aims to manufacture batteries for electric vehicles, that business is going to require a significant amount of capital to get started. You'll need machinery, technology, etc. So $100,000 is probably not going to be sufficient for that type of business. You would have to show the government what a typical amount is to start that business. And then you'd have to show them that a substantial investment amount has been invested. I raise that example only because what that $100,000 threshold that we use would not apply to a business that is more expensive to get started. The government, as I mentioned, does not have a set dollar amount. The government does, though, talk about what's called a proportionality test. And basically what they say is, if you are starting a business that is relatively inexpensive to get started, inexpensive is a relative term. We would think of inexpensive as something around $300,000 or less. A business that requires $300,000 or less to get started, the government will want to see 100% of that investment amount spent on the company before the application for the visa is submitted. A business like the manufacturing business that we talked about before, which may cost millions to get started, the government doesn't require 100% of those funds to be invested. So it may be possible to apply with 80% of that total invested into the company. So that's what the government calls the proportionality test. The more expensive the business is, the lower the percentage that the government will expect to see invested at the time the visa is applied for. Now, if you do have a startup, one of the ways to show what a sufficient amount is to invest in the business is to get a letter from a CPA, a certified public accountant, or to include in your application articles from business publications that do show the government what a typical amount is for that business. An example I like to use is I had a client who started a tattoo parlor in Boston. And what we did was to get publications from tattoo magazines, tattoo trade publications, to show what the typical amount is to start a tattoo parlor, and to show that our client had actually spent significantly more than that amount to start their business, therefore showing that the amount invested was substantial. Something to keep in mind, what the government's really looking for in the investment amount is two things. First of all, they're looking to see if the investor is serious about the business. And the government takes a pretty simplified view of this. They essentially are asking, do I feel as a consular officer that this applicant has put enough of their money, their personal funds on the line at risk to show that they're serious about this business? The second thing, though, is that they want to see that the investor has spent everything that's necessary for the business to be real and operating. So meaning that they have really bought everything that's necessary for that investor to then get a visa, come to the US, and start running that business. Something I didn't mention before is that the government will look to see that the funds that were invested in the business are from a lawful and legitimate source. So the source of the funds is another aspect of an E2 application that the government will take a look at. You can, as I mentioned before, buy a business, and typically the fair market value of a business that's on the market, as long as you are paying the market value for the business, that would usually be sufficient to prove a substantial investment amount. Franchises are a good option for E2 visas because they come with them kind of a track record or an infrastructure where you can say, here is the roadmap of what we will do to grow this business, and you can show that that franchise is successful elsewhere, and that yours therefore is likely to be successful. And finally, there are good and bad E2 visa expenditures. Good expenditures really are those that clearly go toward contributing to the growth and operation of the business. Inventory, office space, hiring workers. These are all things that clearly, when an officer looks at them, they are likely to say, of course, you need those things for the business to operate. Bad expenditures are those that the officer looks at and doesn't see clearly how they contribute to the business. So the cost of flights, the cost of hotels, meals, if you are coming to the US to look for a business opportunity, those would be weak E2 expenditures, and we would typically recommend that they not be included in the list. There are others that we work with our clients through and would be happy to talk with you through a consultation if you have specific questions. With that, I will pass it off to Ian to discuss the National Interest Waiver.
Great, thank you very much. Thank you very much, Dustin. So yeah, so as Dustin mentioned, the E2 visa is one that a non-immigrant visa that we regularly process, and it's an excellent visa for entrepreneurs. But the one downside of the E2 visa is that it is a non-immigrant visa, so you have to continue to renew it, and in essence, it isn't a green card. So that brings us to this category, the National Interest Waiver, which is an actual green card. And it's a category that starting in 2016, the end of 2016, there was a case that was decided, an appeals court case that was decided called Matter of Dinosaur, where that particular case specifically mentioned entrepreneurs and really opened up this category for entrepreneurs and investors. And since that time, it has been used, used as the category, green card category for entrepreneurs and investors. So there are a few things to consider in this particular category. The first is that it does fall under EB2. So the green card employment-based categories go from EB1 through EB5. And today we're going to talk about EB2 and EB5. So, but this falls under the EB2 category. And the EB2 category is broken up into national interest waiver petitions and then other petitions where an employer is sponsoring the individual for a green card. Now, the reason this is important is because the EB2 category has a threshold requirement, and that threshold requirement is that the individual has to have an advanced degree or equivalent or exceptional ability. Now, let me just describe what those mean. So an advanced degree is a master's degree or higher. So someone who has an MBA, for example, or someone who has a PhD, or the equivalent. And the equivalent is someone who has a bachelor's degree plus 5 years of progressive work experience. So that's that's what defines an advanced degree. Now, if someone doesn't have an advanced degree, so let's say, for example, someone just has a high school degree, and they can still qualify under the EB2 threshold requirement if they have exceptional ability. And you'll see that there are a number, I think there are 7 criteria that are listed on the slide. And if you meet 3 of those criteria, then you are deemed to have exceptional ability, and if you have exceptional ability, then you would meet the threshold requirement. Now, one of the reason I spend a bit of time going through this is because we do have a lot of applicants that come to us and say, hey, I see these EB2 threshold requirements and I have an advanced degree or I have exceptional ability, so is that enough for NIW? And the key thing to take away is that that is just the threshold requirement. So that's just before you even consider moving into the EB2 category, whether it's for national interest waiver or whether it's for the perm, a company sponsoring you for a green card, you have to meet one of these requirements, either advanced degree or exceptional ability. So now if you meet one of those requirements, and it's either or, so if you have an advanced degree, you can stop there. If not, then you have to move to exceptional ability. So then if you meet those, then you move to the more complicated part of the national interest waiver petition. And one thing to keep in mind with this particular category and all of the categories that we're going to talk about today, we do have separate webinars on each of these categories. So those webinars sometimes span between 45 minutes and an hour. So these, when we go over these now, we go over them a little because we have to get through 4 of them. We don't spend as much time on them, but if you go to our YouTube channel, you'll see previous webinars. We have webinars scheduled, every week. Actually, not every couple of weeks. Every week we have a couple of webinars scheduled. So they'll, each of the topics that we're going to talk about today, with the exception of the next topic that we're going to talk about, and we'll explain why that one we don't have as many webinars with respect to it. But you could easily sign up for one of those webinars to get more detail on these. And as I said, there's a specific webinar on national interest waiver for entrepreneurs. We have one regular national interest waiver and then one national interest waiver for entrepreneurs. So when we look at the actual 3 requirements of the national interest waiver, the first is that the first thing, whenever someone comes to us and says that they would like to, or they're interested in national interest waiver, our first question to them is, what is your proposed endeavor? Like, what are you saying that you want to come to the United States and do? And we get them to define exactly what that is. Now, and that leads us to the very first requirement, which is that the proposed endeavor has to have substantial merit and has to be of national importance. So, for example, someone that was coming to the United States to introduce some particular type of innovative technology, or someone who was coming to the United States to do research on some scientific scientific procedure, someone who's coming to the United States to start a business and wants to, that in itself might be their endeavor. And then when we look to whether or not it has substantial merit or national importance, if we look at the investor side or the entrepreneur side, the importance could be the creation of jobs, or the importance could be if the business is producing a particular item. We had a national interest waiver that we did for an entrepreneur, and we argued that the national importance was the job creation, but we also argued that the national importance was the product that this particular business was creating, right? So we won't get into detail of what that product was, but there were a number of arguments that we were able to make where we were able to link the particular product to things that the U.S. government found important. So that's kind of the first requirement of a national interest waiver, and that particular requirement is looked at independent of the individual. Right. So that's just looking at, this one should be easy to meet because you can frame it really any way that you want. It can be as grand or as minor or minimum as you want. But then we move to, well, it can be as grand as you want or as minimum as you want, but it may not meet the requirement, right? But in terms of if you're just defining, this is what I would like to come to the United States to do, that is something that you can define so that you work with an immigration lawyer, so the immigration lawyer believes that that would meet the requirement. But then we move to the second requirement. The second requirement is that you're well positioned to advance the endeavor that you described in prong 1. So not any endeavor, the endeavor that you described in prong 1. So that's where it becomes a bit more difficult, right? Because If you say that your endeavor is that you're going to start a business, and let's say that you say that the national importance is job creation. So you say that I'm going to start a business and I'm going to create 100 U.S. jobs, and then you get an economist report that says the impact of creating 100 U.S. jobs is going to be X, Y, Z on the economy, and then you get other reports that talk about how the U.S. government says that they're interested in job creation and things like that. But now, when you're looking that you're well positioned to advance the endeavor, you're looking at, are you well positioned to create 100 jobs, right? And they're not just going to take your word for it, right? They're not just going to say, well, he or she has a degree, an MBA, and he or she has started a company. They're going to be looking at very, very concrete items, probably much more concrete, I would say, than what they would look for example, approving an E2 petition. Very concrete items that show that you're going to be able to advance this. Now, so one of the things they like is that you have a track record, that you've done it before. If you say that the national importance is going to be that you're going to create this large company that hires, that will employ hundreds of people, that you've done it in your home country, that you have done this before, and you provide evidence for that. They'd want to see that the company has been capitalized. They might want to see that the company has contracts already, so that it is going to be viable. If the country's already operational, if the company is already operational, like, so let's say that it was an E2 business and you're moving from E2 to National Interest Waiver, and that business has been operational for years, then they're going to want to see the contracts that you have, the employees that you've already hired, and tax returns to show that, yes, it does look like this particular company is on target to achieve what it is that they said they could do in prong number one. So, we're obviously going to include some things like the educational background. We're going to include things like work experience, et cetera, but it is going to be a lot more, because on the face of it, the requirement itself that you're well positioned to advance the proposed endeavor, it seems like it's an easy one to meet, but it is the number one reason that national interest waiver petitions get denied, right? So that's other than maybe there's a one other reason, and improper preparation of the petition, but or incompetent preparation of the petition. But in terms of for petitions that have some merit, the number one reason that they get denied is prong number two. And then we look at the third requirement, and what the third requirement is getting at is that the government already has, Congress has indicated that it is in the national interest to require companies that are sponsoring people for a green card. So if you're sponsoring someone for a green card under EB2 or EB3, it is in the national interest to make sure that the person goes through a labor certification process such that the company cannot find a qualified U.S. worker, right? So they say that national interest is to protect U.S. jobs, right? So that's in the national interest. So they say that the third requirement for national interest waiver is that, on balance, that it's beneficial to give this person a green card, even though they haven't gone through the labor certification process. So we point to a number of positive things about the applicant. Sometimes we look at the EB1 criteria, the extraordinary ability criteria, and see if we can say that, well, look, at this person is so exceptional, and that's one of the reasons that that's one of the reasons that that's one of the reasons that this person we should waive the labor certification. But in particular for entrepreneurs, and when we're looking at investors, this one can be an easy requirement to overcome, because one of our biggest arguments is that entrepreneurs that own over 50% or over of their company are ineligible for labor certification. So we kind of argue that the whole discussion of, why shouldn't we give this person a green card because there's labor certification doesn't really apply, because the person isn't really eligible for labor certification, just based on the labor certification rules. If you own 50% or more of a company, you're not eligible to be sponsored by that particular company. And that particular argument is one that is successful, that has been successful, and it's one that we use, and it's one that really only entrepreneurs can use. So I think it's definitely a good one. So yeah, so definitely in terms of looking for a green card, this is a great option, and one that we have used and will continue to use at the firm. So
Go ahead, Ian.
the
Sorry.
some of these things on this slide we covered we covered. And I think that, when we look at the National Interest Waiver specifically for entrepreneurs, I think a couple of things that particular case that I talked about changed. And one of the big things is that before that case, one of the main reasons that national interest waiver cases would be denied is because the case that applied before this really required an impact that expand across the entire United States, and that was often difficult to do. So if basically your company was just a company that was in, set up in one geographical area, then you really wouldn't be eligible. But this case made it clear that the geographic scope. It's not that it's irrelevant, but it's not it's not required that the national importance expand to the entire United States. You could, for example, have one of the key cases related to national interest waiver for entrepreneurs is an individual who had started a very small consulting company. In the opinion, it says multiple times, small consulting company, and if your organization or company is set up in an area, for example, that's an economically depressed area, then that in itself could be in the national interest. And there's lots of newspaper and other articles that would point to that. And then we talked about the second bullet point already with respect to how it is that we argue that the labor certification, for the third prong, how it is that we argue that the labor certification is not really relevant for that particular prong. And then the other kind of thing to keep in mind is that Danisar case very explicitly says that this particular category, it doesn't have to be that the applicant will ultimately succeed as long as they can show that it's more likely than not to succeed. But I will say that although the case explicitly says that, we cite to it and things like that, but under prong 2, the company does have to be either pretty far along, or you have to provide substantial evidence that the company actually is going to be able to achieve what it is that you indicated in prong 1. So this particular case study is it's an actual case, and it was an individual who set up a small consulting company, and he was setting it up to help U.S. vets that were coming back from combat and integrating back into society, and it was a small consulting company. And what he did was he basically showed, and what happened with this case, it was submitted and it was denied, but then he appealed, and then the appeal board came back and said, well, yeah, this is a legitimate case, and described why. So we're able to use aspects of that case. So what he did, he submitted letters and newspaper articles and research reports that, where the government clearly said that integrating vets back into the society and providing these types of services, were important. And then in terms of him being well positioned to advance the endeavor, they pointed to things like the fact that his small company was capitalized, so he had some money in a bank account. He had a number of contracts already, and letters from different, government officials and leaders that said that, they were going to, they were interested in the services that he was offering. He had a detailed business plan that he'd executed, and so all of those things, the appeals case indicated that he was actually well positioned to advance the proposed endeavor. And then for the third prong, the particular case cited back to exactly what I talked about with respect to it's impractical for the applicant to obtain labor certification because they are, they're not eligible for it. So there's case law to support this, and often when we do national interest waiver cases, we are pointing back to different appeals board cases that we've seen.
Perfect. Thank you, Ian. So we will now switch to the third of the 4 options that we'll be talking about today. This is International Entrepreneur Parole. Hopefully this is going to be the shortest segment of today's presentation, because unfortunately, the government apparently has not done anything with international entrepreneur parole. It is difficult to find an example of someone who has been approved for international entrepreneur parole or denied. So even though a number of applications have been submitted, the government apparently is not making much progress at all on these. So on these applications. So what is International Entrepreneur Parole, or IEP? You sometimes see this abbreviated as IEP. IEP is a program that was initially launched in 2017. It was frozen under the Trump administration and officially relaunched in May of 2021 to great fanfare. Many of us were very excited about it. Unfortunately, as I mentioned before, that's really the last we heard of the program. Who is this program intended for? So IEP is really for people who, in our minds, who do not have the citizenship of a treaty country that would make them eligible for an E2 or an E1 visa, and or those who are starting businesses where they either don't own 50% of the business, or they plan to take on external investment so that their ownership stake will be diluted below 50%. IEP is for those entrepreneurs whose startup has a significant potential for significant growth, rapid growth, and rapid employment, rapid job creation in the US. This is, you can imagine this as kind of, the Y Combinator type startups, the ones that tend to get significant attention from the public, and people want to invest in it. Maybe venture capital firms may want to invest in it, or even private citizens or permanent residents may want to invest in the startup. This is not a good fit typically for someone, say, wanting to start, a more typical brick and mortar business, such as a restaurant or maybe a convenience store. Those IEP is probably not a good fit, just because of the requirement for significant growth and rapid job creation. It's important to emphasize that IEP is not a visa. It is also not a green card. IEP is parole, and what parole is when the government permits the individual to enter the US without being formally admitted into the US for a very specific purpose. And the purpose here is to grow a business. So one of the consequences of that is that if you are in the United States on parole, you cannot change or adjust your status from within the US. If you want a different visa status, or if you want to pursue a green card, you have to leave the United States and apply for that at a consulate. Family can join the entrepreneur on IEP. They would need to file an I-131 application for travel authorization in order to do that. And they can either file that at the same time that the entrepreneur applies or afterward. So let's talk a little bit. Oh, and the spouse should be eligible for work authorization, which they would apply for once they enter the US. They would file an I-765. Let's talk a little bit about the requirements. Again, I don't want to spend much time on this, just because the government's not doing anything with it. We hope that changes, but for the time being, and since 2021, there has been no progress on this. So to IEP, the maximum amount of time that someone can be on IEP is 30 months. 60 months is 5 years. There are two phases. You would apply for initial parole, which is 2.5 years or 30 months. And then at the end of that period, you would apply for an additional 30 months. And there really are two sets of criteria, whether you're applying for initial parole or for the renewed 2.5 years of parole. the initial requirements, the requirements for initial parole, the owner, the entrepreneur must own at least 10% of the business. The business must have been founded no more than 5 years before the date the application is submitted. And the startup business must have received investments of at least about $264,000 from qualified US investors or government funding of at least $105,000. That investment must come, if it's from private investors, from US citizens or entities controlled by US citizens or green card holders, lawful permanent residents in the US. And the investor really does need to have a track record. This is supposed to be, say, a venture capital firm. The government uses that investment as almost a litmus test to see whether this is a business that has gone through, jumped through the hoops. And basically the government says, we as the government are not really good at figuring out if a startup has high growth potential, but if there are venture capital firms that do this for a living and they say this is a business that can do that, then we will take that for what it's worth. Now, if you cannot satisfy that third requirement of the required investment amount, there is an alternative option for you. And essentially that is to show the government through the variety of examples of evidence that you see on your screen that this is a business that has a significant likelihood of having substantial growth and substantial good job creation. So I'm not going to go through each of these. You can see them on the presentation, but documentation that shows that the entrepreneur, the owner, really does have a track record of success and is likely to repeat that success in this business, growing revenues, growing income, and creating significant jobs. You can also include evidence of the reputation of those who have invested in the business, whether they're venture capital firms or startup accelerators, again, like Y Combinator and startup accelerators of that nature. You can show that this startup has already generated significant revenues. It's already employing a significant number of people. If you have patents, you would emphasize those, that you're creating important, highly valued intellectual property. You can include letters from the government or other entities that really are experts at evaluating these businesses that are in the field in which your business operates, and says, this really is a business that has a high likelihood of success and growth and job creation. Press coverage is something else you can include. Really, the way to think about this is the time to really not be humble and really to put your company and yourself front and center and show why you're likely to create a significant number of jobs through this business. To apply, you would submit what's called the Form I-941 to USCIS. If that's approved, you would then go to a consulate and get a boarding foil from the consulate. And then when you enter the US, you essentially enter with parole. And again, that is supposed to just be a single entry for the purpose of running the business. If you are at the end of those 2.5 years, again, no one has reached that point yet, both because we're only a 1.5 years in, but also because no one is yet on International Entrepreneur Parole to our knowledge. At the end of that 2.5-year period, you should be able to renew or apply to renew. You would need to own at least 5% of the business. So initial parole, you need 10%. It's okay for it to drop to 5%, but not below 5%. And then while you are in the period of re-parole, you need to always own some part of the business. It can drop below 5%, however. The entrepreneur does not need to personally invest for IEP. Again, it's okay to show that there's outside investment being made toward the business, as long as the entrepreneur does have that required ownership stake in the business. Their own personal investment is not required. Up to 3 people, 3 entrepreneurs can apply for parole based on a single startup. And as I mentioned before, you cannot change or adjust status in the US while you're on parole. With that, I'll pass it back to Ian to talk about the EB-5 green card.
Excellent. Thank you very much, Dustin. So yeah, so now we move to another green card. So and this green card is one we do a lot of work with this particular green card for investors, in particular investors who perhaps are on an E2 visa and then decide that they would like a green card, and then they invest more money in their business. So generally the EB5 program is a program that allows an individual to invest either 800,000 or 1,050,000 into a business, and then if that business can create 10 full-time jobs, then they could get a green card. So in terms of the difference in the investment amount, the 800,000 would be invested if the business was located in what's called a targeted employment area, and a targeted employment area is defined by an area that has an unemployment rate of 1.5 times the national average. So the TEAs, or targeted employment areas, are going to change. And then also, it could the 800,000 would work if the business was located in a rural area, and the investment is made in what's called a new commercial enterprise. But that's really an enterprise that was started after 1990. So this could be, the investment could have been made some time ago, or the investment can be made over time. Could have been made over time, and it could still qualify for an EB5. In terms of this particular program, it's gone through a lot of changes lately, but now it's pretty settled in terms of the investment amount is settled, and the rules related to EB5 are settled, and they were settled in March of 2022. So really the changes that were really disrupting this program in the past don't really exist anymore. In terms of the investment, and in particular, this is focused a little bit more on, because there are kind of two ways you can invest through the EB5 program. One is through what's called a regional center, where your investment is being made in a project that someone else is running. So let's say someone's building a hotel and they're trying to attract investors. So that's kind of one way. But then the way that most entrepreneurs, I think, that we work with have invested is that they are starting or investing in a business that they want some control over, or the ability to run and control. So both of those options are permitted under EB5. But when you are investing money in either of those two options, there are certain things that are included in the investment. So for example, money that you pay for legal fees or other administrative fees that are paid can't be included in the investment, whereas with E2 they can, but unfortunately for EB5 they can't. So you do have to be careful with respect to what is included. The other kind of thing to keep in mind is we do have a lot of E2 clients, for example, where their business does really well. So let's say that they invest, $100,000 in their E2, the business really takes off, and then in a year they have, profit of net income of $2 million, and then they, reinvest that in the business in the following year. And then they come to us and say, well, I've invested $2 million in my business. I want to apply for EB5. But the retained earnings of an existing business doesn't count towards the investment. The EB5 investment has to be your personal investment that comes from outside of the company. The other big thing with EB5 this requirement exists for E2 as well, but EB5, the source of funds requirement is quite extensive. So the government really does go to extreme length to show that the source of funds comes from a legitimate source. And it sounds like an easy requirement, but it is a very difficult one. The EB5 investment has to be an equity investment, so it can be a limited partnership unit, it can be a membership unit, it can be a share, but it can't be, you couldn't give a company $800,000 and then take a loan back on it. It can't be a debt instrument. It has to be an equity instrument. When it comes to the job creation, we are looking at 10 full-time jobs or roles. So part-time jobs don't count. And also in terms of the jobs have to be to US citizens or green card holders. So often with EB5, it is very important to maybe use something like E-Verify or something like that when you are hiring people, because right as you hired them whether they were qualified to work in the United States. Because when you do come back later and try to remove the conditions on the application. That's something that the government is going to know whether those people are U.S. citizens or green card holders. So if someone gives you false documentation, for example, that would be a problem when you came to prove to the U.S. government that you created the U.S. jobs. The petition can be approved before you've even created one job. So you have a detailed business plan, and they will approve an I-526 petition just based on a plan. So there's no, the business doesn't have to be advanced or anything like that. You just have to have a credible business plan, and they will approve it. And then the transfer of the funds or the investment has to be linked to job creation. So if a company has like 5 employees working there, and then you invest in that particular company, you'd have to create 10 additional jobs, because the 5 jobs that were there already are not going to count, because there's no link between the investment amount and creating those U.S. jobs. And then we talked already about full-time jobs and having to document that. In terms of the petitions that are filed, there are a number. So the I-526 petition is the primary petition. One of the big changes in March was that now we're able to file the I-485 petition concurrently with the I-526 petition. So if you're in the United States, you're able to file the I-485 petition, provided your visa category is current. And if you're outside of the United States, then you would do something called consular processing. And if you are here in the United States and you file the I-485, you're able to file for travel and work authorization. And that's really important, because the I-526 petitions are taking a significant amount of time to be adjudicated, over 4 years to be adjudicated. So an individual who's in the United States, since March, now that they're able to file the I-485 petition concurrently, really has a significant immigration benefit, because they are able to live and ultimately work in the United States. And then 2 years after you have the green card, you file an I-829 petition, and that petition is one that is to remove the conditions, basically saying that you have created the you've created the U.S. jobs. And that is really it for the EB-5.
Perfect. Thank you, Ian. So we have not received any questions yet. I will go over the summary that you see on your page, and in the meantime, please feel free to send in any questions that you may have. We have discussed these 4 options that you see on your screen. First, the E2 visa, which fortunately and unfortunately, the government has not set a clear required investment amount, which means that if you do have a service-oriented business, a consulting firm, a law firm, you can invest a relatively lower amount. No set number of jobs to create, though we do recommend 3 full-time equivalent jobs over the course of 5 years. And you must have the nationality of an E2 treaty country to apply. The National Interest Waiver, the endeavor must be in the national interest. You must be well positioned to advance it, and you must show why labor certification should be waived in your case. That's typically not hard to show if you are an entrepreneur. International Entrepreneur Parole rule is a new program. We have not seen any approvals or denials, no movement at all on this program. And as a result, we're also not sure of what the processing time will be. We don't know when the government will start acting on those applications. And the EB-5 green card. So there have been recent changes to the program, including the required investment amount. 10 full-time employees must be shown in order to remove the conditions on that green card. And there is a very long wait for the I-526 petition and the I-829, but fortunately, you can concurrently file the I-485, as Ian said, as well as the applications for travel and work authorization. So we did have a question come in. What has been your experience with the international parole? We have not seen any movement at all on international parole. Applications have been filed. We are not aware of a single case in which the government has either approved or denied one of those applications. No movement at all. Okay, with that, thank you all for taking the time to join us today. Ian, thank you very much for your time and expertise.
Thank you.
Please keep an eye out for our email.
Excellent.
We
Thank
hope
you
to
very
see
much.
you on
Okay.
future webinars.
Take care. Bye-bye.